A warning, this episode discusses sensitive material, including sexual violence.
In 2014, Abduwali was sentenced to 5 years in prison after breaking into a woman's home in Te Puke and sexually violating her, claiming he committed the crimes to get deported back to his home country, Somalia.
In 2020, Mohammed Abduwali was released after serving his time for charges of burglary and sexual assault. Then,
his most recent victim, we'll call her Stephanie, was sexually violated by him at her home in Palmerston North in 2020.
He was released again late last year.
I still think he's a really high risk of, if he hasn't already, of going on to traumatise others in this same way.
But corrections has mechanisms for keeping watch over offenders. One of those is called an Extended Supervision Order, or ESO. The parole board was concerned with Abduwali's history and the claim that he could, quote, identify consent through eye contact and body language, and applied for an ESO. That request was denied. Kia ora, I'm Davina Zimmer, and on The Detail today, how extended supervision orders work to keep the public safe, and if being convicted of the same offence twice isn't enough for an offender to be put under an ESO, what is?
I was shocked about the risk that this person poses for the community.
That's victim advocate Ruth Smith. She's been worried that with Mohammed Abduwali out of prison and not under extended monitoring, it's only a matter of time before he reoffends. But while recording this podcast, a corrections spokesperson informed us he has been remanded in custody for breaching his release conditions. We'll come back to the Abduwali case and Ruth soon. But first, what threshold needs to be met for an extended supervision order to be granted?
What you need to be able to prove to say that this person is a very high risk, you should need a lot of evidence, and it should be strong evidence to establish that.
Graham Edgler is a Wellington-based barrister who works in defence and has represented clients with ESOs.
Extended supervision orders are essentially a person has gotten to the end of their sentence in prison. We can't keep them in prison any longer. They've gotten to the end of their parole period, so we can't have sort of any conditions like that anymore. They have literally served every day of their sentence, and corrections decides, actually, we want to keep monitoring this person, even though they have served their entire sentence.
And why might corrections decide they want to keep monitoring this person?
Generally, because they think that person is an ongoing risk and has to be a particularly high risk of committing a serious offence.
Okay, and so let's talk a little bit more about that. What is the criteria for someone to be put under an extended supervision order?
Well, they have to be under a finite sentence. So anyone who's committed a murder and gotten a life sentence or something like that, they can't be on an extended supervision order because their sentence lasts for their entire life. Even if they're not in prison the whole time, they'll be on parole. So it has to be someone on a finite sentence that's come to an end, and it has to have been for a named serious offence, which is generally serious sexual and serious violent offending.
They also need to have been sentenced to prison, still be under corrections management, and have a pattern of behaviour. Next, there's the psychological assessment.
Then you go to court and you have to prove that they are a high risk of serious sexual offending or a very high risk of serious violence offending. Once you've done that, the judge can look and ask the question, how will an extended supervision order actually help mitigate these sorts of risks? I know of a few cases where it was agreed that this person was a high risk, but it was a high risk of a type of offending where them being supervised wasn't going to make much of a difference. Putting an electronic bracelet on someone, for example, so that you know where they are. If the type of offending they're doing is familial offending with a person who lives in their house, extended supervision just isn't going to help stop that sort of offending. And then you're looking at, well, what type of conditions? And so as a general rule, for the first year, you might be allowed what's called intensive monitoring. monitoring, that 24/7 monitoring that's going on. And then after that, you can have various stepping down of the process at that point up to the parole board of what levels of restrictions about where they can go, whom they can be with, whether they need to be electronically monitored, whether they need sort of a drug and alcohol tests, things like having to take part in rehabilitation, maybe alcohol counselling or education programs. And sort of at that point, you're arguing about what sorts of conditions will help ensure that this person isn't put in a position where they're likely to reoffend.
So where would you fit into this? You would be the defence lawyer?
Yes, so I've represented a number of former prisoners in respect of whom corrections have applied for extended supervision orders, would get copies of the documents like you would in sort of any criminal case or civil case. And then it's a matter of working out, has the legal standard been met? Is there enough proof here? Making corrections or putting them to proof. You're like, is this really necessary in this particular case that you need these sorts of orders, given that this person has served their entire sentence?
And how do you measure whether someone poses a real and ongoing risk?
Corrections will get evidence from psychologists largely, who will conduct assessments and compare the factors that apply to a particular person, what type of their offending was involved, how much it has been repeated. It's statistical evidence where you're comparing them to other offenders who have been released who had similar factors in play.
And when you get one of these, is your automatic thing to always fight it? Or are there times where you look at it and you say to your client, no, look, this is a reasonable request to have been made?
I mean, it is up to the client whether they want to fight it. Just like, most people who are charged with a criminal offence do plead guilty in the end. And quite relatively common with extended supervision orders for the argument to be about not whether there should be an order, but perhaps how long the order should be, or what particular conditions should be imposed. And the types of cases I've done over the last few years, we've been fighting largely over what's called a public protection order, which is the more serious type of order that corrections can get, which involves physical detention, inside a wire that if you didn't know the difference, someone looking at it from the outside would think that's a prison. And so quite common for people when the evidence is so strong, where they might be arguing, I will agree to an extended supervision order, but I won't agree to the more serious public protection order. And so in a lot of those more serious cases, a person is agreeing that the order should be made, but perhaps having an argument, or not that particular order, or this one, and we want to make sure that, all the full suite of quite serious restrictions aren't in place, or potentially aren't in place for too long.
And so run me through what kind of restrictions would be imposed on a person who is under an extended supervision order.
At its highest, a person can be required to be at a corrections facility outside of prison wire, where they can be monitored 24/7 by the Department of Corrections staff. They're wearing an electronic bracelet. Their phone or internet might be either denied or restricted. They may, if they're ever going to go out, have to be accompanied by one or two corrections officers, and sort of all the other types of restrictions that you can have with anyone on parole. They can be told you can't go to public parks, or you can't enter this particular town where your victim lived. They can have curfews where they can't go out during certain hours. During the first year of an extended supervision order, that curfew can be 24/7.
An ESO can last up to 10 years, but corrections can apply to have it extended if they think the offender still poses a risk to the community. So are ESOs working?
It's been a couple of years since I asked corrections for reoffending data of people on extended supervision orders, but the number of people who are on an extended supervision order who have seriously reoffended is very low. We're talking about hundreds of people with convictions for serious sexual offending who have been under these orders. The number who have actually committed those sorts of offences, particularly while under intensive monitoring under extended supervision order, unless it's changed dramatically in the last couple of years, I think it's sort of a count on the fingers on one hand type of area.
The numbers may not be very high, but nevertheless they do happen. One case I can think of is the Blessy Katinko murder that happened on the North Shore.
The Auckland woman was raped and murdered in 2014 by a convicted sex offender who was under the department's watch.
Should it even be possible for someone to reoffend under an ESO? I mean, the point of an ESO is that they are under this intense supervision.
People who are dangerous, we don't punish them until they actually commit a crime. And that's sort of the general idea here, and that's sort of how our sort of criminal justice system was designed to operate, is we punish people after they offend and not before they offend. And when you're talking about someone on an extended supervision order, they have been punished already for that offence. They have served literally the entire sentence. And now we are doing a level of monitoring to keep them going. But we don't want to, keep them imprisoned for a life sentence or something, effectively, keep them locked up forever for something which, when they committed that offence maybe 15 or 20 years ago, they've been punished for already.
It takes a lot of evidence to prove someone is a high enough risk to society to place them under an ESO. Corrections had its ESO application for twice convicted sex offender Mohammed Abdulwali rejected on the grounds that he didn't meet the criteria. Graham wasn't involved in this case, but says the high bar to issue an ESO is appropriate.
You should need a lot of evidence, and it should be strong evidence to establish that.
I mean, the victim may argue that the fact that he offended in a similar situation twice, that it does show that he is at risk of reoffending. Do you not think that that is the case?
I don't know how anyone tells how someone is likely to reoffend. And that's sort of one of the problems I had in courts proving it, particularly when you're getting the higher levels of orders of someone. this person is a 40% or 20% chance of reoffending. And when you're dealing with sexual offences, 20%, 30% is actually what they call high. It's not even a flip of a coin. Someone is a 25% chance of reoffending sometime in the next 10 years. That can be enough to get this sort of order.
I think it's really important that the community understands that there are things that corrections do, or at least apply for, to keep us safe.
Victim advocate Ruth Money agrees that while there should be a high threshold for placing someone under an ESO, they are essential in certain cases.
While we'd love to think that there aren't, and that we'd like to get rid of all the prisons and we don't need incarceration, there are people who keep reoffending and they are dangerous.
Judges decide whether to issue an extended supervision order based on the facts and tests which Graham outlined earlier. But what happens if some of those facts are wrong? In his decision, Judge Brett Crowley said, quote, "There is no established pervasive pattern of serious sexual offending in Mr Abdulwali's conviction history." Ruth Money disagrees.
Abdulwali has been a repeat offender. There have been a number of charges, and a number of charges he was found guilty for.
So there was the case in 2014 where he was sentenced to 5 years and 9 months.
Yes.
And then there was the second case in 2020, right? Yes.
So a case where there were multiple charges. In the judge's decision, it talks about that Mr Abdulwali had been acquitted of 2 charges. That's incorrect. He had not been acquitted. The jury couldn't decide. They were a hung jury. If he'd been acquitted, that would mean, he's not a repeat offender necessarily, right? That's 2 charges off his charge sheet, off his previous behaviour, making it a weaker argument that he would be a repeat offender. But he wasn't acquitted. The jury couldn't determine whether he was guilty or wasn't guilty. So it's contextually quite different. The other thing I would say is that the judge erred, or the judge got it wrong, where he said in his decision that the brave victim survivor invited Mr Abdulwali into her home. She absolutely did not. Mr. Abdulwali conned her into saying, I need some water, and he followed her into her home where he sexually violated her. Very different, and the facts are very clear. Evidentially, it is very clear that she did not invite him in.
Ruth says in the victim's initial statement she told officials Abdulwali had followed her into the house, but the parole board recorded that she invited him inside. It's the latter recording of events which the judge used to make his decision. Ruth says the Parole Act is very clear on the threshold that needs to be met for an extended supervision order, and the judge did follow the rules.
This judge did make a really concerted effort to work through all of the different points within the legislation to see whether he believed the threshold had been made or not. However, he was making it on incorrect information, I believe.
So the threshold, is that like a point system, whereas like you score a number of points and if you're just shy you don't get
Kind
it?
of. That would be kind of helpful, actually.
Yeah.
No, so it's Section 107 IAA of the Parole Act, but it talks about certain things as to whether the court can determine the risk is enough or not. So, for example, one is whether there is an intense drive, desires or urges to commit acts of violence, or extreme aggressive volatility. Persistency is another word that's used. Premeditated goals. So there are certain descriptions within the law that guide the judges in their decision making. Interestingly, though, and I think this is a good part of the Act or the law, I think the quote actually in the Act is, any evidence or information that the court deems as being appropriate for them to use to decide, they're able to. So it's a little bit different to a criminal trial, for example, where the evidence is just, has to be, quite appropriately, specifically about that one offence. When you're deciding on an ESO, when the court decides on an ESO, they can hear from all sorts of people about all sorts of information that may be relevant to the ESO. So a victim can supply information to the court to help them decide whether an ESO is appropriate or not, for example. That doesn't normally happen in a criminal trial where you're determining, for example, a burglary.
So once an ESO is granted, does it do enough? Let's go back to the murder of Blessy Katinko.
Tony Robertson had been out of jail less than 6 months when he murdered Blessy Katinko. He had to wear a GPS bracelet, but that didn't stop him. All it did was silently record how and where he'd been scouting for a victim and a dump site.
How close is the monitoring? Like, is it to the extent of they have a cop following them around their every move?
No, absolutely not. And I've been quite vocal about that in the past. For example, Tony Robertson. He had already shown complete disregard for the ESO. He had also shown escalation in his behaviour. He'd been found around schools and parks, and he is a very dangerous recidivist sex offender. And no one had recalled him, even though he was, allegedly being closely managed under an ESO program.
Is that a signal that perhaps ESOs aren't working or working as they should?
I think the majority of ESOs probably do work as they should, but I don't believe that the New Zealand justice system, and most of this comes under corrections, identifies and manages what we call the 1%ers, the most high-risk offenders. I don't believe we have the skill set to be able to do that. We don't recognise, manipulation. Paul Tainui is another one.
The last parole board reports written about double murderer Paul Tainui describe him as faultless, having a good rapport with staff and consistently assessed as posing a low risk of offending. The reports are part of the evidence in the dual coronial inquest in Christchurch, looking into Nicole Tuxford's rape and murder and his first victim's father's suspected suicide.
There are incredibly manipulative, dangerous people who we call the 1%ers, who need to be managed by experts in sexual offending, manipulation, premeditation, and we're not there yet.
What are we missing?
I think we're missing resources for a start. It costs a lot of money to manage someone closely, but it's also a skill set that isn't here. It's not trained for. We don't have a high-risk sex offenders team. In other countries, I work with an ex-UK detective who is a child exploitation and child abuse or sex abuse expert. And, they have multidisciplinary teams, and all they do is monitor high-risk sex offenders. And we don't have that ability here.
Could we have that ability?
Yeah, we should. We absolutely should. Ask Nicole Tuxford's family, should we have that ability here? If we did, Tainui wouldn't have been free to murder Nicole.
And bringing this back now to the Abduali case, now that this decision for an ESO has been rejected, what happens now? Are there any other ways that can protect the community and help the victim feel safe?
Well, she's gone out and got cameras, etc., etc. So we leave protection of the survivor up to the survivor in New Zealand.
Crown Law has the right to appeal the ESO rejection, but Corrections has told us they have decided not to in this case. However, Abduali is currently remanded in custody. They say if he is released, he will be closely managed and assigned a probation officer for regular contact. I asked Ruth if we should feel worried.
Look, there's not everybody that you come across and you're walking past in the street is certainly not a violent sexual offender. However, they do live amongst us, and we need to be really clear with ourselves and particularly our children about managing risks. I certainly don't want to put fear into everyone, but we do need to be really realistic, and we do have to be very aware that most sex offenders are manipulators, they're groomers. They're not going to drive around in a van and grab you. There are a small percentage that do that, but the great majority of sexual offending happens with manipulation and grooming.
Devil's advocate would say that if someone has served their time, they should have a chance to have a normal life, and being subject to an ESO in certain measures stops that. What would your response to that be?
I don't disagree with that. This isn't something that you've done once and they're going to start slapping ESOs around the place. It just simply isn't like that. There are so many safeguards in the legislation, as you can see with the Abduali decision, that makes it hard for Corrections to get an ESO quite properly, because you have served your sentence for that particular crime. Should you go on to repeat it, should you be pervasive in your behaviour, then it's only appropriate that the community is protected. When you go for a job and you fill out your CV, you put all your experience down there. This is the bit that I never understand with repeat offenders. You put all of your experience down there to prove that you are well practiced in something. I've done this here, I've done that there, and yet when we turn to criminal justice, we have to look at each individual event on its own merit. Of course we do. But that's what the ESO is for, to look back across the CV, to look back at the history and go, we have a risk profile here that is unsafe for the community. We need some additional measures around it. So I, for one, am really happy that they exist.
That's it for today. The Detail is a newsroom production supported by RNZ and New Zealand On Air. This episode was engineered by Phil Benge and produced by Gwen McClure. Thank you to Ruth Money and Graham Etchler. I'm Davina Zimmer. Ka kite anō.